I'm Jay Sekulow, Chief Counsel for the American Center for Law and Justice and counsel in the Supreme Court for Operation Rescue. There is no doubt today that the Supreme Court expressed serious concern over the scope of applying RICO to social protests and the implications it would have on a variety of social protest activities. I think it's also clear that the injunction that was issued here is going to be dissolved. The court was very skeptical of this nationwide injunction, and the court was also very aware that the application of RICO to social protests, whether it's Operation Rescue's activities or whether it was the sit-ins of Dr. Martin Luther King, applying all of that activity to RICO would be a very dangerous precedent, and every one of the justices expressed very serious concerns about it. So at a minimum, I think that RICO, as it applies to social protests, will come to an end by the Supreme Court. I'll take a few questions. This is Randall Terry. He is the founder and director of Operation Rescue.
The question is this. Ma'am, please. The question is this. Do we want a judicial guillotine to silence all civil disobedience protests? If the NOW's interpretation of this law succeeds, it will be like dropping a guillotine on the head and the neck of all civil disobedience protesters. We have to remember something here. We've done jail time. We've been sued in federal and state court. Some of us have lost everything in our lawsuits, and yet they still want to pursue us under racketeering laws. It's absurd. That's why so many groups that don't even agree with us on abortion have sided with us in this case, because they see it as a threat to civil protest. One other problem is this. It's an ironic moment when those who kill children and maim women through abortion are the victims, and those of us seeking to rescue children, those of us that are seeking to help moms, are the mobsters, are the racketeers. It's absurd.
Mr. Terry, wasn't your objective to close down abortion clinics?
We will. I want to clarify one thing here for the point, and then we'll answer your question. And that is this. The court expressed the concern that the scope of RICO would apply to, under the government's theory as well as National Organizations for Women's theory, to any social protest movement. And that was expressed by a number of the justices, and I think the scope of that concern is what's going to be the overriding issue in this case.
Well, but sir, what about Justice Souter? Then defined it by saying that the difference could be the taking away of a business, the prevention of a business, and changing the way that business is done.
Yeah, but that is a distinction that, in our view, was tried in other contexts and has never withstand scrutiny. Remember, in this case, and I think it's important here, the jury instruction was that women being interfered with to obtain abortion constituted an act of extortion. They rejected it. You cannot possibly, this case at a minimum would have to be retried because of the jury instructions in this case, with I think all the justices, including Justice Souter, objected to.
But what about
let's get Mr. Scheider.
Yeah.
Mr. Scheider.
One other point while Joe's coming. Under NOW's argument, Dr. King and the protesters at the lunch counters would be mobsters. So Dr. King is not a national hero, he's a gangster.